Hello, welcome back to the Data Privacy Lawyer. It's Funmi, the principal attorney speaking. Today's review is going to be on xAI. We're doing a series on the channel right now. We're looking at terms that are on a business's website that address the use of artificial intelligence. So if you're new to my channel, I have a law firm that focuses on data privacy and data protection advisory. The reason I think it's really relevant to start looking at these AI terms is if you are brand new to the planet, artificial intelligence is generally being utilized in some capacity at every organization now. I don't know any organizations that aren't using artificial intelligence. Now, from a data protection perspective, it's really important to take a look at how companies are processing your personal data in relation to their AI, whether it's a tool they have, whether it's a system that they have, whether it's they're creating their own artificial intelligence. Their responsibility under the data protection law is to let consumers know how they use AI and how it pertains to the personal data they collect on individuals. So without further ado, we're going to look at these terms today. Now, there's something else I want to make a note of for organizations. It's really important that you are explicit in your public-facing privacy documentation about who the entity is. Now, I've never really called this out, but one of the recurring themes that I generally see is companies generally will have many different legal entities, and the name that goes on your public-facing website should address the entity that consumers can reach out to. So if you go by something like also known as, or as a acronym, or if there is a different way in which you present your business to consumers that does not reflect the name of your legal entity that's registered in the geography where you operate, you need to be very explicit about that on your privacy notices, on your cookie notices, terms of service that you expect consumers to agree to. Make sure that you are very explicit about the name of your legal entity. And I also love here that xAI LLC has addressed the geography where they are headquartered, Nevada. Now, something I'm going to say about US state privacy laws, just because your organization is headquartered in Nevada does not mean that the only adherence to data protection laws are exclusive to Nevada. Now, that's really important, and many organizations aren't aware of this, so I thought I would call this out specifically since this particular entity has addressed what the name of their legal entity is. This is what's registered in Nevada, just so that you're aware. If you're providing products and services outside of Nevada, you need to look at the data protection laws in those geographies. That's very important, and we'll probably see some of that in this terms of service. The other thing I want to say is that this is effective November 4th, 2025. Now, I want to make it clear, the first thing is that some data protection laws actually require you to make sure that you update the last updated date for your terms of service. So it's really important for this to be something that's done, automatically every single time. My general inclination for when I'm speaking with individuals and businesses is make sure that this is updated on an annual basis. You need to re-review any public terms that you are providing to consumers. One, for a number of different reasons. You need to ensure that how you operate the business has not changed, because these terms, I'm just going to make this clear, our enterprise terms of service govern the use of our services for developers and businesses. Now, if this has not changed in a year at all as it pertains to personal data, I would be very surprised, because businesses are constantly evolving, they're constantly changing their methodology, they're constantly changing their business operations. Each of those three things that I've just outlined generally are going to influence how you process personal data. For example, let's say that you work with a vendor, and this vendor originally provided you with a service and they've been providing you with that service for 10 years. And then they decide to beta test AI in the product that they provide you. And they send you a message as a business. They're like, oh, do you want to beta test this artificial intelligence for the product you already have? That changes how you offer your services, right? That changes how you process personal data. That influences. And that needs to be reflected on your terms of service or your privacy notice, because it influences how you process personal data. And under the data protection laws, you're required to be transparent about your privacy practices. I don't want to spend too much time on that because I really want to get into these terms of service. The reason I've introduced the terms of service into the review for data protection is because depending on the service that you have, it may influence what you're agreeing to on a public-facing website. Even in the terms of service, even if an organization like this one has already addressed in their privacy notice how they process personal data, there may be specific provisions that you have to agree to in order to have the service. For example, you agree that our artificial intelligence may process your personal data for analytics. That's something that would exist in the terms of service. And then there would also be a subsequent provision in the privacy notice that says, hey, this is part of our privacy practices. So there's kind of a duplication between both public facing documents. Now, my general prefer that terms of service are distributed via email or something that's not so public facing. And I'll tell you why. Especially if you're a large organization, your terms are generally changing often. Having them on the website and then changing the actual service could be burdensome for you to continue uploading and changing these terms of service. Whereas if you're distributing them via email or via PDF or some other signatory platform, you're able to make those changes internally and then you can distribute it as and when the terms change, right? Anyway, let's go through this. So xAI is a company working on building artificial intelligence to accelerate human scientific discovery. But essentially, generally, in order for companies to build and train their artificial intelligence, they are using personal data in some capacity. Now, I'm going to preface this by saying that the term personal data, when it comes to organizations and how individuals understand personal data, may not necessarily fit exclusively into what the definition of personal data is under the data protection laws. I'll give you an example. So for example, an IP address. An IP address basically is like computer information that allows you to identify like a device sometimes, or where somebody is like logging in. It gives some sense of geographical information. It's a computer identifier. Now, looking at it on its face, it's just numbers, right? But under the data protection laws, an IP address constitutes personal data. So even if an organization is using something like those numbers, the fact that you're able to hone in on the general geographical location of an individual constitutes personal data and has to be accounted for by organizations. And that's what a lot of businesses don't understand when it comes to AI. Maybe, right, I don't have insight knowledge, but when I'm drafting these types of documentations for my clients, I always take a look at what their internal documentation says about how it is that they're building this artificial intelligence, because that'll influence not just the terms of service, but it also influences the privacy notice too. Okay, as part of our mission, we have developed Grok, a conversational generative AI powered by xAI's large language models. We also provide Grokipedia, an online collection of knowledge. Now, this is not my client, but if it was, I would have a number of different questions about how the generative AI was built, what type of training data sets were utilized in order to develop Grok and Grokipedia. That's really important. They have the opportunity to understand exactly how it was built and then how their personal data will be influenced by utilizing either of these services. Okay. Minimum age, you must be at least 13 years old or the minimum age required in your country to use the service. Now, I'll explain why the sentence exists here. The data protection laws, depending on the geography, we'll talk about the US, but essentially there is a data protection law called COPPA, and it regulates how children's personal data can be processed. Now, the reason why this sentence exists is because generally you need parental consent if you're a child. And the reason why they've given a range here, 13 to 17, is because different data protection laws consider what constitutes a child between generally this age range, right? In some geographies, a child is considered anyone under the age of 13. In some geographies, it's under the age of 17. So they've provided this buffer to accommodate for all of the geographies where Grok and Grokipedia are offered. Every provision in your privacy notice goes hand in hand. And this is why it's very important and why I am generally against companies opting to use a boilerplate privacy notice that they're able to purchase online. Because you have to look at your products and your services. That's why it's so important to liaise with a privacy counsel. Because if you go onto the internet and you try and create or download a privacy notice and just slap it on your website, you put yourself in harm's way. One, if a regulator ever reviewed it and it's not in line with the products and services that you offer. And then two, the nuances related to the data protection law aren't generally captured in those generic privacy notices. I'm going to continue going through this and just look at it from a lens of what I, as a participant in creating these types of terms and service, generally looks at for businesses, right? You must provide accurate and complete information to register for an account to use our service. You may not share your account credentials or make your account available to anyone else and are responsible for all activities that occur under your account. I'm going to highlight the sentence because I want to talk about it. You might be saying, why exactly is this organization sharing this information with me? Generally, The data protection laws provide rights to individuals based on their own personal data. If you as an individual choose to share your account credentials or make your account available to anyone else, there could be an argument that they have rights pertaining to this personal data that's processed by this organization. So they have to be very careful to indicate to you what it is that they're going to be responsible for, what it is that they are not going to be responsible for, and you're agreeing to that if you use any of these services, right? Grokipedia and xAI's other services for individuals, including associated applications and websites. Now, I really love this, and I didn't address it before because there's so much material in this video. We're not going to go over everything. If you're looking for a counsel to help you draft terms of service, take a look at my description below. I'd love to work with your business. But essentially, the other thing we're going to mention for this terms of service is make sure that you're explicit about what's in scope, because that also influences what the provisions below are going to state. And again, that's not something you're going to be able to capture if you purchase a boilerplate privacy notice off of the internet. I really hope you enjoyed this review. If you like my videos, subscribe, and I will see you in another video.